Hey guys, today we get to talk about a very big update in the Ethan Klein versus Denims lawsuit. The lawsuit is for copyright. Keep that in mind. It is a protective order. Now, what is a protective order? I'm glad you asked. So in this video, we're just going to go over legal stuff. In my next video, I'm going to explain why this is going to be so difficult for Denims, and that will be more of a opinion-based video. But in this video, let's give you guys the education you might need or want. So in a copyright case, a protective order is a formal order issued by the court that sets rules for how certain information exchanged during the lawsuit must be handled. It's mainly used during discovery, where both sides exchange documents, data, and testimony. Because copyright disputes often involve sensitive materials like confidential business records, trade secrets, financial statements, and licensing agreements, or unpublished creative works, the parties may not want that information becoming public. So, protective order usually limits access. Certain documents may only be seen by attorneys, experts, or the court, not the opposing party directly. Prevents disclosure. Sensitive information cannot be shared publicly with competitors or on social media. This is a big problem in today's society, and I think it would be a very big problem for Denims. Specifically, defines categories. Material might be labeled as confidential or highly confidential, attorney's eyes only. Sets procedures how documents are marked, exchanged, and filed with the court under seal. It provides remedies. It outlines what happens if someone violates the order. For example, are there sanctions, contempt of court, even possibly jail time if you continue to violate the order. So this is a very interesting document now, and we see this all the time. Logan Paul versus CoffeeZilla. There is this back and forth of what is confidential, what is not confidential, what is protected, and what is not protected. And you also saw that when CoffeeZilla was asking Logan Paul for his private text messages, and Logan Paul, his manager, and someone else's phone numbers, they got leaked by the court. So this is a very, very important stage. We are now at the stage of discovery. In a copyright case, a protective order is a formal order from the court that governs the handling of sensitive information. Without a protective order, all documents exchanged could, in theory, be shared more freely, which might harm one or the other side. The protective order provides a legal shield and restricts disclosure and ensures fairness. Copyright cases often require disclosure of unpublished works such as manuscripts, music demos, software source code, or early drafts. We are talking, of course, about the Hassan the Nuke. What did that initially look like? What parts were left in and what parts were left out? Drafts, copies. We also saw that with CoffeeZilla's videos. CoffeeZilla, he has an editor. He had to show early drafts of what he was investigating and such. So financial profits, licensing revenue, royalties, cost, business agreements. How long did it take them to make the nuke on Hassan, right? Business agreements, contracts with publishers, distributors, or licensors, trade secret, marketing strategies, or proprietary technologies. So, what is when you mark something as confidential or highly confidential, attorney's eyes only? What does this mean? Confidential means parties, attorneys, and experts can see it. Attorney's eyes only means only lawyers and sometimes experts can see it, not the opposing party personally. So you're trusting that the lawyers not going to report back to their client what they saw. They only can summarize why it's important or not important. So here we have receiving party, scope. Scope is really how broad, how narrow the scope is of discovery is going to be vitally important. Obviously, when you are on your end trying to discover information about the opposing party, you want that to be as broad as possible. When they're doing discovery on you, you want it to be as narrow as possible. Once a case proceeds to trial, all the information that was designated as confidential or maintained pursuant to this protective order becomes public and will be presumptively available to all members of the public, including the press. Designating protected material, exercise of restraint and care, and designating material for protection. Each party or non-party that designates information or items for protection under this order must take care to limit any such designations to specific materials that qualifies under the appropriate standards. The designating parties must designate for protection only those parts of material. So you cannot. There are two questions here: what is confidential, and then what is not confidential. And that question, what is not confidential, often is probably the more important of the two questions. It's going to be interesting because you could spend a lot of money in this. You could spend a lot. If you don't believe me, you can look at Logan Paul versus CoffeeZilla. They are still going at it for this part of discovery. CoffeeZilla says, I have journalistic privileges, First Amendment privileges, attorney-client privileges, and the back and forth is, hey, this is confidential. Logan Paul's, hey, it's not. Hey, it's confidential because of my attorney-client privilege. And Logan Paul's like, no, it's not. And then the judge has to decide each single piece. And often the judge will look at it himself or herself and then go back to, and then Logan Paul may never have seen that information. There might be information out there where it's tangentially related to the lawsuit, but it's actually what Logan Paul wants to know, which of his crew members may have betrayed him. Still, given the size of his crew, Logan Paul still has no idea who has given the inside information to CoffeeZilla. CoffeeZilla is doing his best to protect that person's information, or that person's personal information. It kind of reminds me a little bit of the H-free snark, but in this case, it's, that person's completely anonymous. Maybe not to Reddit, but to everyone else. So, challenging confidentiality destinations. This is going to be really important. Meet and confer. Ideally, they would kind of figure this out themselves. They would not want to have the judge involved. When the judge gets involved, they're often very grumpy. It's a lot more work than they want to do. It's extra work, and it's a decision that could theoretically be appealed. And if it's appealed, then that makes the judge look bad. So it's better for them to meet and confer, which means they have decided how to handle that discovery issue by themselves. So we are in discovery. Discovery is often a phase where very little happens until a flood of it happens. There are going to be a lot of emotions here. There are going to be a lot of, I would say, things that you may not, that may come out, that maybe somebody doesn't want it to come out. And what does that look like? We don't know. And that's the beauty of discovery. Are there emails, or there text messages, or there drafts? I mean, what is there going to be that we don't know? That's why we have discovery. Are there text messages between Denims and the H-free moderators? Are there text messages between Denims and Frogan that can be used in Frogan's case? Discovery is very interesting because in the Logan Paul versus CoffeeZilla case, we got a bunch of text messages from Logan Paul that didn't make him look very good. And now Logan Paul, in spite, maybe just kind of like, oh, haha, you got me, I'm going to get you, is now trying to get a lot of private text messages from CoffeeZilla to editors, to sources. It's a very long, drawn-out process. Discovery often is the longest leg of the race. And it is just like people disagreeing because, again, you don't know. We saw the H-free snark case where they say, oh, we never communicated with Denims. you cannot think that is true, right? That's their version. That's their best version of what they're saying. They could be lying, and that would be interesting to find out. And there is a so your lawyer has a standard. Your lawyer cannot go up there and lie and be like, "Oh, there's no text message between Denims and the moderators at H3 Snark." If your lawyer sees a text message between your client Denims and H3 Snark moderator, which he can figure out is H3 Snark moderator, they will have to turn it over. And this is another way for Ethan Klein to figure out who the H3. I've always said this. I mean, there's 4 different parties, defendants, right? There's Frogan, there's Denims, and there's Caseytron, and there's the H3 Snark moderators 3 different times and 3 different lawsuits. Now, why do you need 3 different lawsuits? Well, maybe Denims didn't talk to H3 mods. Maybe Caseytron did. Maybe it was Frogan. Maybe it was all 3 of them. Maybe it was some combination of 2 of them. It would be fairly interesting because they're going to have to turn over their text messages, their emails, and so on. Now, you fight it and you say it's confidential, but the principles of confidentiality that would apply often would be journalistic privileges. In fact, let me list you what could be confidential and what could not be, right? Let me think. I made something for CoffeeZilla about it. So, confidential in court, not publicly available, restricted access for litigation only. So, what are the privileges? What are the defenses when somebody says, "Hey, attorney-client privilege"? Okay, so that's number 1. Attorney work product. That's the one that CoffeeZilla really used. So that's the one I want to say. Attorney work product. Common interest. Mediation. Settlement. Here are some other lesser-known privileges. Spousal privilege. Doctor-patient or psychotherapist privilege. Reporter's privilege. That's the one Logan CoffeeZilla is using as Logan Paul. Journalistic shield. So, I mean, those are the typical privileges that people use. There's 7 of them. Will any of these apply for Denims? Probably not. I mean, I don't think Denims can call herself a journalist, right? CoffeeZilla for sure is a journalist. I do not think Denims is a journalist. Denims, we're going to get into my next video. Denims has a big mouth and she likes talking a lot. And we saw with Destiny how this could actually harm his version of the case. In my opinion, if Destiny's just stopped talking about the case, he would have already won. He's making the case really complicated because the case is no longer about the card 2, right, which we've covered on the channel. It is more about, the current motions are all about that did Destiny talk about something he shouldn't have talked about? Well, if he never talked at all, there wouldn't be that motion, and I think the case would have already concluded. But because he's doing things and talking about things that he really should not be talking about, even if he believes he can talk about it, the question is, should he talk about it? And the answer always from a lawyer is no, please do not talk about it, because you're just going to you're asking for more motions. And each more motion kind of drags the case longer. That's not typically what you want to be doing, because when the case drags longer, the court might find a reason to actually, in this case, help Pixie figure out what the argument should be. Where Pixie, previously, her lawyers did not have a good argument, they may have a better one now. Anyway, let me know what you guys think in the comments. I'm going to give more of my opinion. This is more of the legal basis of a protective order as an educational tool for you guys. I will give you my opinion on this a little later. Bye, guys.